can start, yeah. Right. Hello, everybody, and welcome to session 5 of SCL India's roadshow on FIDIC contracts. And as I was thinking about it, it's been 5 months, I think, that this series has been going on. And that's quite an achievement, actually, to have so much of consistency with what we initially started with. And now that we've reached the second last session. And I want to thank both Keating Chambers and Driver Tret for their constant support. And, every bit of last minute support that they could offer, they've always offered it. And of course, I also want to thank Ketan and company for their valuable support through all these 5 months. So we're heading closer to the end. And it felt like we needed to also sort of take some time to sort of dedicatedly discuss contractor claims separately and employer claims separately, because I think they both deserve a good amount of deliberation. And that's how we've landed here. So we've already discussed session 4 contractor claims. So for those who want to sort of do a recap of it, can always go back to our YouTube channel and visit all the previous sessions, including the one that happened before, which was on the contractor claims. And now we come to the corresponding side of it, the side which always opposes the employer side. And for that, we have 3 gentlemen with us. And I'm very glad that all of you were able to take time to be present here. And as the months go by, I start really wondering. I mean, 2.5 hours is quite a long time for for practitioners to spend and sort of contribute towards this particular session. And I'm very, very thankful for that, especially. By now, I think those who have been watching us are pretty familiar with the faces that you see on the screen. So I'm going to keep it a little more interesting by requesting each of them to speak something interesting about themselves, and not about law or about the specific profession they do, because all of that, you can find that online. One could always Google each of these celebrities and find more about it. And David especially, look at the background and behind him. And he very humbly puts it that these are the projects that he's worked on in his lifetime, just a few of them, right? So let me start with Ranjit. I think you're the fresh blood in the series.
Okay, indeed.
So indeed. Ranjit is an in-house counsel with ISDPL, which is part of the Demi Group, and he has a very specific position here, in my view, because he has been with the employer side for quite some long time, and now he's with the contractor side. And 2 contrasting experiences that he's had in the last 5-7 years. And I'm very interested to sort of hear from you as to what you have to say about the employer's claim now that you're on the contractor side and dealing with it from the opposite end. So let's start with you. If you could just introduce yourself a little bit, and then we'll sort of go around the panel.
Right. Let me start right off the bat. We've been having, my name is Ranjit, and like Gracious has just mentioned, I'm an in-house counsel. But I wouldn't say that in front of my 2 senior colleagues. I want to be very specific here. I use that word colleague with utmost humility, because these are stars in their field. And we were just having a chat about cricket. And so I'd like to say I do feel like the night watchman, sort of between 2 great practitioners, stalwarts in their field. And so I'm sort of sandwiched in between them. So yeah, sort of feeling like the diversity hire. But more than that, I'd just like to say that because Gracious asked us to say something interesting about ourselves. And so other than the field of law, I actually had an opportunity of doing some stand-up comedy at one point of time in my life. And I have to say that it has brought me great joy. And so I do continue to believe that is one of my stronger suits than law. And I think I'm going to end up hungry. But coming back to what Gracious was saying, of now that I'm in a place wherein I'm supporting the contractor's claims and having all my life been a part of the employer's setup. So I have to say that, some people are either from the employer's side or from the contractor's side. And I continue to believe that my heart rests with the public procurement policies and it rests with the employer. And so I tend to get a little peeved off even though the people footing my bill expect better of me. And I'm constantly trying to pull them down. So I'm trying to learn. I won't lie to you. Working on the contractor side is very new to me. This is something I've only done for the last 6 months. But working on the employer side has truly been eye-opening. And I do believe that it makes me very, very exotic, because I don't think there are too many people who are lawyers who've actually worked on projects, and that too ones that are multi-billion-dollar projects, particularly of national importance. And again, the Official Secrets Act forbids me from specifically naming a project, and Gracious is here to ensure that I don't say the name of the project, because both of us have been involved in it. But the honest truth is that there is tremendous joy in working on the employer side as well. And I think more practitioners are needed on the other side as well. And I think it was on our last conversation when I was speaking with these gentlemen, they said, well, isn't it more often than not the case that the claims are from the contractor's side and the employer's claims are so hard to find? So I actually happened to read something on the internet that I found rather interesting. Employers' claims are like unicorns. Everybody knows they exist. Very few people have seen them. And so the truth is that I believe that there is a lot that we can learn from this session, particularly for me. And I'm glad that I'm sitting here and getting a first-hand opportunity of interacting with these gentlemen who are absolute stalwarts in their field. And so I'm looking forward to this, but I'll hand it back to you, Gracious. I think I've said enough to start off.
All right. Thanks, Ranjit, for that introduction and for sharing a few thoughts. Now we'll go to Paul for his introduction. Paul's a director at Driver Threat, and we've heard him a few times before as well. And he's been such a constant support, I think, for SCL-India's initiative. So I want to thank you especially for that. So Paul, something interesting about yourself, a few thoughts maybe that you could share.
Well, in the UK, we have the profession called a quantity surveyor, which I know you do as well. Mm-hmm. And the quantity surveyor is normally the butt of jokes. The quantity surveyors are in the likes of accountants, that we're all very, very boring types of people. And picking on Ranjit, I mean, some people might think that actually I should be a comedian rather than a quantity surveyor, because the quality of my claims have been sometimes pushed away by employers with big smiley faces all over them. But no, seriously, we touched on cricket. I love my cricket. I was at Edgbaston for the part of the first test with Australia, and I got absolutely rained upon, as did England in the end. But I was going back to semi-serious, I was given a training for a global company a little while ago, a few years ago now, and they were predominantly German. And it was in the time, I think, of the Football World Cup in Japan. And I think it was Mexico had just beaten Germany. And we were in the bar that night, and the Mexican team were really going into the Germans. And then one of the guys turned around and says, "Hey, but you have cricket. You know, how would you explain to somebody the rules of cricket?" And I tried to start, and then I remembered that, and I urge anyone who loves cricket to do this, Google comedy rules of cricket. And there's somebody who's written a wonderful piece about cricket, trying to explain that when you're in, someone's trying to get you out, but sometimes when you're out, you're in. And then when those that are in are all out, the other side come in and they try to get them out. And then I turned this comedy thing into trying to explain FIDIC 2017 clause 20.1. And I likened being in as the contractor submitting a claim, and then it's rejected, but we might not really be rejected. So it's not in, but it's out, but then it's back in again. So I can, if anyone wants it, I can send you the piece. It's on the Driver website under knowledge somewhere. I think it's called It's Not Rocket Science or something. But yeah, I like to bring a smile to people's faces if I can. I may not be a stand-up comedian, but making people smile is wonderful. That's enough.
Thanks, Paul. I don't know, you just have a way of just bringing back FIDIC in every bit of the conversation that you always have. You just somehow do it. I mean, it's great. David, we'll move to you. And once you've done your introduction, you can also sort of start with your presentation as well. We'll start with you, go to Ranjit, and then Paul likes to tie things down. So we will move to Paul at the end. So David's King's Counsel at Keating Chambers, And I think now, again, this is his second time that he's appeared here in the series. But besides that, he's also visited India now a couple of times. And so we're glad that you're here, David. So something interesting about yourself?
Thank you very much. Most people think that's quite a challenge for lawyers to find something interesting about themselves, but I'll do my best. You referred to the pictures behind me. Right. They are indeed some pictures of projects where there were dispute cases, litigation or arbitration that I was involved in. I can see certainly 3 different continents there. You can see Africa, Asia and Europe just reflected in the screen. They're also just picking up another theme of Ranjit's, really. Those pictures behind me enable me to claim to be a neutral because I think they're roughly half I was involved for employer and half for contractor. So I think in the role that I play, you do get instructed by one side and then the other. And I think over the years, it's worked out about 50-50, although you tend to get phases of going one way or the other. But anyway, so Ranjit, be very happy to talk to you about being poacher turned gamekeeper or gamekeeper turned poacher, as we say in England. As to what else I find fun outside the law. I'm also very keen on cricket, but with England having been all out for 325, conceding a first innings lead of 91 at Lords, I think perhaps I won't say any more about cricket, especially as I'm speaking to India, and one of the great things about your country is the love of cricket, and I think how you have kept it alive and given it tremendous energy and enthusiasm around the world, and are spreading it around the world now. And only to see the success of it in the United States, it's fantastic to see, and I think that's in very large measure due to the fantastic energy for the game in India. So that's great to see. But anyway, given England's performance today, I'm not going to say any more about it. The other game that I love and that I actually play now, I play cricket once a year still, but I play tennis a lot. So that's my other great love, and I try to play tennis once or twice a week. So love that. And we've got Wimbledon coming up as well, so maybe that'll have to be more my focus. Apart from that, I'm very keen on my garden. Actually, both my wife and I are very keen gardeners, and we're lucky enough to be able to also a couple of times a year we open our garden to the public, and those are very joyous occasions in which we get to share what we've done and raise some money for charity. So that's
going to be one of my things to do when I visit London.
Yes.
David's garden. Just put it in the itinerary.
Yeah. So anyway, a bit of sport and gardening. That's I guess the things that I love. In addition to the law.
All right. Well, thanks, gentlemen, for that introduction and keeping it lively. And I hope that the conversation on employers' claims can also be as lively, because now that we have to go back to reality and talk about contract provisions in the law. So I guess we could start with David, with your presentation and your segment. And I will share the screen now for your presentation. Okay.
Well, thank you, Gracious, very much, and for doing the screen sharing and flipping onto the slide. So there we have the title. It's Employers' Claims under FIDIC. And if we go to the next one there, or just next slide, it just sets out the structure of what I'm going to talk about. I'm going first because I guess I'm doing the kind of legal framework that we have for employers' claims under FIDIC 1999 and 2017. And then the others can really look at matters more practically. So that's I think my role in it. So I'll just look at the key clauses in each of the versions that are still in use. I probably heard in previous talks that FIDIC 1999 still very much in use, and as Paul alluded to, FIDIC 2017, much more complicated contract, quite a lot of criticism about it, 60% longer than 1999, 90 different definitions, and greater complexity and obscurity about it in places. So in many ways 1999 remaining very much in use and more popular. Why on earth they didn't just do some simple amendments and improvements to the 1999, I don't know. But anyway, we'll have a look at employers' claims under both, see the main differences. And what we'll be looking at really is, well, how do these clauses work? When do you have to give notice? Are they conditions precedent? What are the notice requirements? What particulars do you have to give? What's the scope of these employers' claim clauses? And how do employers' claims get determined? So that's really what I'm going to cover by way of what is really the legal introduction to this. So if we have a look at the next one, please, Gracious, will be the 1999 clause that's at the heart of the matter. Now, I've given you this in full. It's, I know, a bit of a full and boring lawyer's slide, but there it is, and it may be useful for you to have it to hand in future if you want to look back at these slides. It's different in the 2017 version, but here we have clause 2.5, employers' claims, and let's just have a look at it, some of the wording, because this will come back later on in this little talk of some of the key provisions. So it's if the employer considers himself to be entitled to any payment under any clause of these conditions or otherwise in connection with the contract, and or any extension of the defects notification period. So that's what it's applying to. And just note that entitled to any payment under any clause. And just let's stick with the 1999 for the moment. Gracious, I just want to pick up some of the wording. So if we could go back one just to stick with 1999. Yeah, there we are. I think that or otherwise in connection with the contract, that makes it clear it's going to apply to, for example, claims for damages for breach of contract as well as claims under the contract. Then what happens? The employer or the engineer on his behalf shall give notice and particulars to the contractor, and then certain exceptions to that. And I know Paul's going to look in detail about what claims there are available to the employer under the different clauses of the contract. And then the next paragraph is, well, when does the notice have to be given? It's to be given as soon as practicable. Now, notice that there's not any period of days set for that. It's just as soon as practicable. So quite loose, flexible, debatable when that has to be given, perhaps. And it's unlike the provision that applies to the contractor. And it's as soon as practicable after the employer became aware of the event or circumstances giving rise to the claim. Now, it's important just to be aware of the words, because that's the trigger, awareness of the event or circumstances giving rise to the claim. And we'll just come back and have a think about that. And then there's a specific about the defects notification period. And then particulars. Now, it says that what the particulars shall specify, the clause relied on, or the other basis of the claim. So you'd be saying breach of contract, or it's under such and such a clause, perhaps the one entitling to delay damages, most commonly. And it has to be substantiated, the amount of it, or the length of entitlement to the extension of the defects notification period. So got to be particularized. And then the engineer proceeds in accordance with clause 3.5 determinations to agree or determine the amount and or the extension. And then if there isn't agreed, then of course you've got a determination has to be made. Now, you'll note that the clause doesn't actually say when those particulars have to be given. So there has to be a notice and then there has to be particulars, but we'll see there's a case that comes on to clarify that. But there's quite a lot of pieces to that clause, and it's one really to be familiar with if you are on an employer's team. So really, really important under FIDIC 1999. Let's have a look at the next slide then, please, and we'll start to see how FIDIC 2017 is different. And it's in a different clause because what happened in 2017 is FIDIC, in their wisdom, put the employer's claims and the contractor's claims in the same clause. Clause 20 was originally the contractor's clause claim, and they put the employer in here as well. And as Paul alluded to, this really has become a very complicated clause. It's a very long clause. This is just the first part of it. We'll look at another bit in a minute, but it's very convoluted. But anyway, we've got the two sides of the project in here. So it takes a different approach to start with. It starts off by saying when a claim may arise. So we're looking at, what is a claim, capital C claim. And so far as the employer is concerned, if the employer considers that the employer, so quite wordy to start with. Anyway, if the employer considers it's entitled to any additional payment from the contractor, or like this reduction in the contract price and or to an extension of the defects notification period. So there we've got most of what we had before, plus reduction in contract price specifically referred to. B is the contractor, so we leave that aside. C now applies to either party, so employer relevant again here, considers that he or she is entitled to another entitlement or relief against the other party. So that's also a claim. Now another relief or entitlement, that's again going to catch damages for breach of contract, because, as it goes on to say, such other entitlement or relief may be of any kind whatsoever, including in connection with and certificate of termination, instruction, notice, opinion, valuation. But I think anything whatsoever, that's going to still keep damages for breach of contract in there. And then the exception to A and B already covered. And then it goes on, say, in the case of a claim under A or B above, subclause 20.2, which we'll go on to look at because that's where we get notice provisions, applies. And then there's different procedures for subparagraph C. And already you start to get to see the complications of the FIDIC 2017 form, different types of procedure, although they put employers and contractors together, you've got different types of procedure applying for different types of claim in the clause that's supposedly putting it all together and trying to make the aim, I think, was to simplify and make things the same for employer or contractor, but actually you get that complication arising, and there's worse to come. But that's why I think so many prefer FIDIC 1999, perhaps with bespoke amendments. That's still the case. Let's just next slide then, please, Gracious, and we can listed out some of the differences between these two. It's addressed in one place, the procedure for the claims of the two parties, so employer now in with contractor. You find that when you work through all the clauses, and we haven't got time to go through all of this today, but the engineer takes a much greater role in the claims process, and the whole administration of it and the words governing it are much longer, much more detailed, much more prescriptive as to what has to happen. And for example, there is I think this is what Paul was thinking of when he was talking about his cricket analogy of when you're in, you're out, and when you're out, you're in, because whilst notice has to be given by a party making a claim, then there's now a provision for the engineer to give a sort of notice saying you didn't give notice in time if he didn't think that you did. And then there are provisions about what happens if no notice is given by the engineer saying that, and provisions about if there's then a dispute about whether notice was given or not, that then you end up with a review by the engineer, and the engineer in his review has to consider whether anyone was prejudiced by lack of notice, whether the other side knew anyway, and matters like that, all the sort of equity things that influence whether it's right or wrong that you can stand on a notice. So that's really quite a complex procedures being brought in there, but it does mean is one of the ways in which the engineer has a greater role, and it's one of the changes in FIDIC 2017. As we saw, clause 20 now categorizes claims and procedures different depending on the type of it. It's got two obligations that can result in a claiming party, so including the employer losing a right to claim for non-compliance, and these can be an obligation to provide an initial notice of claim. It's within 28 days now for employer as well as contractor, and to provide a fully detailed claim, including a statement of the contractual or other legal basis of the claim within 84 days. So that's come in for employer as well. So ways there an employer can lose its claim as well. So there are lots of other differences, but those are perhaps some of the main ones that apply in this sphere of employers' claims. Let's then just go on to when notice has to be given under 1999 and 2017. RYNS, I'm sure you all know by now, standing for red, yellow, and silver books. So 1999, as soon as practical after the employer became aware of the event or circumstances giving rise to the claim, in 2.5, and it for the 2017, as soon as practicable, and no later than, and see how much tighter it now is for the employer. It used to be like that for the contractor, but now for the employer as well, after the claiming party became aware or should have become aware of the event or circumstances. It doesn't actually say giving rise to the claim there, but if you follow the clause through, you find that if it effectively is saying that, if you follow the cross references back to earlier parts of the clause. So it is really in both of them aware or should have become aware of the event or circumstances giving rise to the claim. And I think it's, as we'll see, it's quite important that it's awareness of giving rise to a claim. It's not just of the circumstance or the event, it's that's going to generate a claim. And we'll just see some cases next, if we may, on the next slide, that perhaps just show the importance of the words. Now, there are two cases that I think are important. One of them recent. These claims are both dealing with contractors' claims, and as Gracious quite rightly said at the beginning, there's much more visibility in the legal learning of contractors' claims than there is of employers' claims. But I think it's right that one looks at these cases on the contractors' claims to inform oneself as to how notice provisions about relating to employers' claims are going to get treated. But at all events, it's what we've got. We're going to come on to one case about employers' claims in a minute, but there's much less learning really. But we still have to look at it to get the guidance we have. Two important cases on contractors' claims, and I'll bring it back to on contractors' claims, but I'll bring it back to employers' claims once we've just had a look at it. I think I hope this is not duplication with what's been done previously, but anyway, if it is, it's revision. So case 9 years ago now, Mr. Justice Aikenhead said, dealing with notice of an extension of time claim from a contractor, said it can be claimed either when it's clear that there will be delay, a prospective delay, or when the delay has been at least started to be incurred, retrospective delay. So clear will be, or that there already is. And some examples of that, you might have severe weather conditions, might be a prospective delay, or just the delay itself has actually happened. Now, that has been recently criticised, and that decision of Mr. Justice Aikenhead, I think, widely respected and held sway for really until quite recently, and may well continue to do so. But it has been criticised in a case, interestingly, from the Dubai International Financial Centre courts. And as I expect many of you know, that is a free zone jurisdiction in the United Arab Emirates, which applies the common law. So it does have relevance to those of us in the UK and India. It applies a broad common law approach, and it considers and criticises Obriscon. It points out that as when the delay occurs. When does a delay actually occur? Well, it only actually occurs once the completion date, be it original or extended, has actually passed. So that means that the effect of the Obriscon decision is that notice can be given very late by a contractor. And that's not really the intention of the clause, which is the whole point of notice is that things are dealt with quickly, contemporaneously, or at least as soon as practicable. So they're saying that can't be right. It's too late, and that led them to focus on the words. It's when the event or circumstance giving rise to the claim, when there's awareness of the event or circumstance, and they have said, and this is it's a court of appeal in Dubai, said it's when there is awareness of the event or the circumstance, and you don't have to realize that is giving you an entitlement to an extension of time as contractor. So many, certainly on the contractor's side, worry a lot about this. This may be great for employers. It is a pro-employer decision, I think, or approach, because it means that even though a contractor may not realize that the event or circumstance has caused a critical delay, may realize it causes an activity delay or disruption, but may not appreciate that it's causing critical delay at the time, and may not appreciate that until a long time afterwards. So it does have really quite a difficult effect for contractors. I think interesting to watch how that develops. Possibly Obriscon went a bit far one way, possibly Panther's gone a bit far the other way, and we'll see how that has to develop. I must say, I'd wish I had been arguing Panther, but there we are. I expect another opportunity will come. But if we think about how that affects employers' claims, or whether it does, and giving notice under 3.5, well, you have to think about what the contract says about, let's focus on liquidated damages in particular, very much the other side of the coin, and obviously one of the most common claims or counterclaims by an employer. So when is there a right for liquidated damages? You have to go and look at that. And it's when the contractor fails to comply with the time for completion. That's clause 8. When does a contractor fail to comply with the time of completion? Well, that's when it's actually passed. So that isn't, on the face of it, a prospective thing. It's when that has actually happened. It is still under clause 2.5. You've got to think about the words considers himself entitled. So there's got to be a consideration that it's entitled to liquidated damages, but there has to have been a failure to comply with the time for completion. So I think that it seems to me that the notice by the employer doesn't have to be given when there is an awareness that the contractor is in delay, or that there is some default of the contractor which is going to cause delay. This will be the debate, I suspect. Do you apply a kind of mirror image of the cases on the contractor's notice to the employer and say, right, well, the employer is aware, let's say, of some failure to provide resources on site, and the contractor is causing delay itself, and that's even, let's say, is aware that that's going to be a critical delay. Does the employer have to give notice? Well, it will be said, I expect that he does. I doubt that very much myself, because it doesn't seem to me that there is an entitlement until the time for completion has passed. So that will be the kind of debate when we are dealing with the effect of the contractor's cases on the employer's obligation to give notice. I think 2017 is going to be the same, because we've got very, very similar wording, but these are debates to be had, I think, in future by the courts. Let's go on to just think about conditions precedent, if we may, Gracious, in the next slide. The 1999 clause 2.5 doesn't actually say that giving notice is a condition precedent. There aren't clear words to say that. At least that's what many in the industry thought. There was then a case in 2015. It's a Privy Council appeal from Trinidad and Tobago, and they settled this, really. And there's a little quote from Lord Neuberger: "It's hard to see how the words of clause 2.5 could be clearer." Well, I wonder about that. But anyway, its purpose is to ensure that claims which an employer wishes to raise, whether or not they are intended to be relied on as set-offs or cross-claims, should not be allowed unless they have been the subject of a notice which must have been given as soon as practicable. So bit fuzzy, because it's only as soon as practicable, but they're saying in that Privy Council appeal quite clearly this is a condition precedent to the validity of claims. So if you want to make a claim for delay damages, liquidated damages under FIDIC 2019, then the employer has to give that notice as soon as practicable, and that's as soon as he thinks is entitled to liquidated damages or any other claim, say for those which are accepted. FIDIC 2017, the wordings that doesn't really need NH International to give that clarification. It quite plainly is wording of a condition precedent, because as we can see there, it says if the claiming party fails to give, and the claiming party will be either party here. It's the same for both sides. So if the employer fails to give a notice of, let's say, a liquidated damages claim within this period of 28 days, the claiming party shall not be entitled to any additional payment. The contract price shall not be reduced in the case of the employer, and time for completion and so on in relation to the contractor. One interesting angle on this is that the NH International case on FIDIC 1999 said this requirement for a notice, and that being a condition precedent, does not apply to abatement claims by the employer. And just to be clear, an abatement claim is when you say to a contractor, well, your work is so poor or your defects are so bad that you are not entitled to payment of the full price under the contract because your work just is not worth it. Now, that's an abatement claim, and they said that this condition precedent notice regime did not apply to abatement claims. Now, we haven't got a decision about FIDIC 2017 as to whether that's going to be the same, but we do specifically have in the wording of of clause 20 and the condition precedent wording, the contract price shall not be reduced. The effect of abatement is effectively to reduce contract price. So it looks rather as if claims to abatement may have been brought within the regime. For sure, something like a negative variation order would be within this regime. One thing that probably isn't, though, is termination. If the employer thinks that it has a right to terminate under clause 15, there are specific notice provisions there. It seems to have its own notice regime, and it's not a claim to payment, whether under a clause of the contract or any other basis. And then if we go on Gracious, please, to the next slide, we can just note, and I'm conscious of time, we can just note what the requirements of the notice are that has to be given. Effectively, is the condition precedent notice. 1999, got to be in writing, got to be communicated to the contractor by whatever the contract says of the agreed forms of communication to the relevant address, and it's got to be copied to the engineer, not in the silver book, but in the others. Both forms, it's actually clause 1.3, which deals with this. 2017, got to be identified as a notice, got to be communicated to the engineer. So slightly different. They're not communicated to the other side, copied to the engineer, but to the engineer. And there's got to be a bit more in it. It's got to describe the event or circumstances giving rise to the cost, loss, delay, or extension of the defect notification period. So a bit clearer about what the content of the notice has to be. Then the particulars of the notice, the particulars that it has to follow the notice, or do they have to be in the notice? We can just look at the next one, please, on particulars. Next slide, please. What do they have to do? Again, it's put differently, but it's called particulars in the first edition, detailed claim in the second. It's got to, 1999, specify the clause or other basis, include substantiation, and this clause requires, as I adverted to at the beginning, it requires the employer to give notice, and then goes on in a separate paragraph saying particulars have got to be given, but doesn't really say when or whether it's part of the notice or later, or how you give the particulars. But NH International clarifies, that's the other useful thing about the case, the particulars must be contained in the notice. So it is just a one-stage process there under clause 2.5. Under 2017, you have to make a fully detailed claim with a detailed description, statement of the basis, all the contemporary records on which the claiming party relies. So more documentation there, and then detailed supporting particulars of the amount of additional payment claimed or amount of reduction of the contract price in the case of the employer or the EOT claim. So again, more prescriptive about what has to be provided with the particulars. And then if we could go next just to consider scope, I think we may really have, I really may have talked about this sufficiently already. We've got the wording there of the 1999 clause 2.5, any payment under any clause of these conditions. So we'll cover liquidated damages, it will cover defects and any losses that occur because of defects and or extensions to the defect notification period. But as I said, doesn't include abatement, and it specifically excludes those two matters of utilities and pre-issue materials. Under 2017, then specifically failing to achieve the time for completion, defective works, which means that the works can't be used for their intended purpose, extension of time to the defects notification period, and defective work which is not remedied by the contractor. More specific again, is it actually different? Well, abatement may be the difference, as I adverted to, that may be the difference in scope. Otherwise, I don't really think there's real difference between them. But important point for employers to bear in mind that it would be wise at least to give notice of an abatement claim in the straight away as soon as you become aware of it. And it's practical to give the notice. And then just a word finally, quickly about, on the last slide, please, Gracious, about determination of the claims. And that's covered by a different clause in 1999. It's clause 3.5, which is the clause under which the engineer makes determinations So if there is a claim, this is what happens. The engineer has to consult with each party to reach agreement. That's the first idea. And if it's not achieved, then the engineer has to make a fair determination and give notice to both parties of either the agreement that has been reached, and that's just for certainty and clarity. This is the agreement with supporting particulars, or of the determination that he or she has made. And then effect has to be given to that unless and until it's revised under clause 20. So that means effectively it applies unless it's overturned by the DAB or in arbitration. Then what if the contractor fails to recognise the determination in his interim payment applications? Well, the engineer can adjust himself to bring that into effect, whether that is increased payment for the contractor or reduced payment or liquidated damages being deducted, whatever it is, the engineer brings it into account. FIDIC, rather different wording, but we've got a specific obligation to act neutrally now. I think that would be there under most jurisdictions by necessary implication anyway, but now a specific obligation to act neutrally, to consult, to encourage discussion and reach an agreement. Nice little example of the wordiness of 2017. Is that really saying any more than consult to reach agreement? But anyway, that's got to be done. Give notice of the parties' agreement if achieved. It's a time limit for it now. If no agreement, then again a time period for the engineer's determination, binding unless corrected or revised under clause 21. That's the DAB and arbitration provisions. It's just in a different clause in 2017, and payments are to be included in the next statement and by the engineer. So the engineer with express obligation to do that. So again, more active role, more prescription of what the engineer's role and the time for his role is set out in the 2017 form. So a bit more complicated, but essentially the same role. And the idea is these claims get determined by the engineer and basically settles them, and they apply unless and until resolved in or changed and resolved in by the DAB or in arbitration. So that was all I was proposing to say. I'm sorry, I've probably overrun a little bit anyway, but hopefully that gives a legal framework to the clauses.
No, thanks a lot, David, for that. I think it's a certain stage for the upcoming talks from Paul and Ranjit. I know you have to leave, but I was wondering if I could, throw in a couple of questions before you do, because we may not have the chance to hear from you later on. But of course, we would obviously like that,
Yes, I'll try. I'm sorry, everybody. I have to go and help a client. On this occasion, an employer with a matter. Yes.
Ranjit, you're on the contractor side. You keep switching back to the.
Don't forget, Ranjit, you're on the other side now.
Let me start with something more basic, and I think Paul would also have something to add to this. What really was the thought process of making it symmetrical between the employer and the contractor to sort of be subject to the same standard of notification period and the requirements for their claims? Are you privy to some of this conversation that took place between them or between the drafters?
I'm not. I'm too young.
or even I don't know. I don't know if there's been any discussion notes or anything like that. Maybe Paul would have some idea. I'm sure he.
I may be a lot older than David, but I'm not privy. I'm quite cynical about this change to have the identical provisions in clause 20. I think over the years, there's probably been a number of employers representatives or whatever that have faced criticism from contractors about the difference in the procedure, especially the fatal notice. And I think it was just a sop. I think it was just a bone thrown to the dog to say, okay, now we can treat you as exactly the same. But as Ranjit said, employers' claims are unicorns. So really, was it much of a concession really in real life? It's nice to have. It's nice to have, but not much of a concession really.
Mm-hmm.
I mean, I was at a book launch last night. Christopher Sapella, who's I class as the daddy of FIDIC, and he's just written a very excellent book. So I'm told. I haven't got a copy yet.
No, this is the Kluwer publication, if I'm not wrong.
Yeah, the red book. Yeah, and I from the launch is going to be a lot of good stuff in there, and a lot of common law versus civil code things and all sorts. But I don't think Chris would have been that unhappy had it never happened. The FIDIC drafters for 2017 were predominantly engineers, and there was one lead drafter, and excuse my cynicism, but she has got on record many times of saying FIDIC 2017 was drafted by engineers for engineers. And as David alluded, the role of the engineer has grown vastly within 17 when compared to 1999. So, it's perhaps a different mindset.
I think you, that's really interesting, Paul. I think you pick up some NEC vibes in FIDIC 2017.
Yeah.
I mean, it's the language of contract data, if you like, has been brought in and straight out of NEC. And I think that, and I think some of the culture has come across from NEC. Now I've written about NEC as some of you know, and you can say things before and against NEC, but what we've got here, I think, is a bit of a muddle between the two. One thing the NEC contract is not is overlong. It has a merit of brevity if parties will only leave it alone. But here we've got this enormously long contract. I mean, really, why did they have to make it 60% longer? That was not the problem. I mean, there were flaws in FIDIC 1999, and I think they could have been improved by making quite brief amendments to a number of the clauses. And I think that's what I mean, Ranjit, you may have an angle on this, is what people do actually, take 1999 and make some fairly modest changes to it to get what they want and keep it in the much simpler, more flexible, more user-friendly form that the old version was.
Especially when you have like a couple of decades where people have gotten used to the 99.
Yeah.
You don't want something completely brand new to start looking at and trying to figure it out. Like, what does it mean? I mean, if it's 60% more, then I think there's 60% more words to interpret now.
Yeah.
Exactly. Yeah. And we weren't even done with the first set.
I
would say that Chris Sapella was not the only panelist last night. So anything I quote is not always to be pointed at Chris. It was suggested, someone did ask from the audience, why is it so much longer? And there were one reason which I can say I can understand. They were looking towards a more civil code audience. So some of the language they suggested was less common law language, going back to the origins of the ICE and so on. And then someone suggested it was to provide clarity.
I don't know.
And there were no more comments.
Exactly.
Yeah. I didn't say anything. I couldn't. I had to zip my mouth. But it was suggested that more words can provide clarity as to the meaning of a short sentence.
It just actually is a field day for lawyers. The more words there are, the more arguments you can come up.
Indeed.
So, indeed. But I think, not from last night, but the Obriscon decision, has been suggested that has led to the new provisions in clause 20. that there's in and out, as I call it in my cricket thing, the in and out, because the Justice Aikenhead said, if I remember the circumstances, it was the widening of the road underneath the runway of Gibraltar Airport.
That's right.
So I think, and correct me when I go wrong, David, an instruction was issued to widen the road. So some people were saying, well, the instruction was issued, you should have been aware that it's going to affect the critical path. But at that stage, the works were not on the critical path.
Mm-hmm.
Yeah. Sometime later, in prospective planning, the works became on the critical path, but there was no delay because they hadn't commenced. And then the third limb was when the works actually commenced, and they definitely delayed the works. So that was, I think, the sort of the three parts of when the notice should have been given. And it was, I think, more of a civil code decision, shall we say, a more fair approach than perhaps the hard black book London lawyer would have done. But I think that's led to a little bit of Clause 20 amendments.
Yes, it's interesting. My own view, for what it's worth, is that Obrascon is, well, there are two extremes, is Obrascon and Panther decisions. What Robert Aikenhead basically said, well, clause says when you're entitled, when you think you're entitled to an extension of time, and you get an extension of time if the completion date is or will be delayed. And he's basically said it's the later of is or will be. Now, what Panther's saying is, well, it's much earlier than that. It's as soon as you're aware of the event or circumstance.
Yeah.
You don't have to be aware that you've got an entitlement. Now, that's really swung back the other way, illustrated by what you've just recalled about the Obrascon case. They've got no idea it was critical when the event happened. Is it really fair that you're shut out when you've got no idea that it's going to delay completion? So I wonder whether we've got two extremes in those cases. I think that Mr. Justice Aikenhead probably got the fair result in Obrascon. You may, I don't know so much about Panther. It may be that was the fair result in Panther as well. And of course, judges and arbitrators are always looking for what's the right result, really. And the merits can affect the decision perhaps more than they should. So I think there are two extremes. I wonder whether there's a middle course of, it's not the later of is or will be, but the earlier of is or will be. Be worth exploring. But I think this debate is going to have further to run. We're going to see more decisions about this because so much can turn on it.
Right.
I'm just going to say, I would hate to see contractors lose an entitlement on a very harsh notice provision.
Yeah.
But having said that, it's only going to be a letter. So if the engineer and the employer want to be flooded with letters, then so be it.
Yeah.
Going back to, I was privileged to be, I think, at the first FIDIC users conference back in something like 2003 in Paris, when the 1999 edition had recently been issued and published. And many of the panelists were actually the likes of Chris Sapella, Christopher Wade, and so on, those that actually had lived and breathed the new contract. And the question of the notice came up then. And I think I may have said this in the last lecture. And they said, it's to be treated as a whole contract. So you've got a contractor that's looking at his progress every month because he's got an obligation under Clause 8. You've got a contractor that's looking at its progress every month because of its monthly reporting. And if that contractor is not really aware of when a problem may arise, does it really deserve? That was the words that were used, I think. Does it really deserve? It's not a very professional contractor that it can't say within 28 days, given all the monthly cycles of reporting, that there's going to be an issue. And it's clarity. I have some sympathy with that, and I like things to be clear. I like clarity, and a black and white notice provision is perhaps okay in my book. Anyway,
that's going to be
back to you, Gracious. That was my first joke. My first joke of the
day. Just a couple of more questions, actually, and I mean, since we were talking about what's fair. And I was wondering about this idea of fair determination that an engineer needs to do on the employer's claim. I've always seen these allegations coming from the contractors about the engineers specifically, especially when, let's say, the engineers, when a lot of their scope or powers have been, stripped off, against whatever FIDIC does contemplate. And we all know that the engineer is basically acting as an agent of the employer. And what hope do you have, as a contractor, to expect that the engineer is actually going to give a fair determination as such, especially when in a certain model of procurement where, your engineer has been the same firm, has also been the consultant, which has initially prepared the designs and the entire tender book and everything. And now, as part of its, scope of works, it has deployed its team to the site and has converted into an engineer. What hope does the contractor have in a situation like this? From an engineer to give fair determinations on the employer's claims. I know this can also operate the other way in terms of how fair can an engineer really determine the contractor's claims as they come to the employer. But let's keep the focus more on the employer's claims. Especially given the privity that exists between the engineer and the employer and all these determinations, they're basically, functioning on the whims and fancies of the employers. That's how the Indian conditions are. Right, Ranjit?
Making me a little yes.
So, Ranjit, maybe you could give us some practicality of it. And then I also want to understand, what is the standard of this fair determination per se?
The honest truth is, everybody seems to turn around, particularly the contractors. And I've personally been accused of this. Oh, well, you're being paid for by the employer. No wonder you're singing their song. He who pays the piper plays the tune. Right. I've heard it enough number of times. But I also tend to wonder, isn't the contractor being paid by the same exchequer at the same time? Why isn't he doing what he should be doing as well? I don't believe that it is a fair comment that the engineer is playing into the hands of the employer. And the honest truth is, the independence of the engineer is paramount, in my mind at least, to ensuring that the contract actually thrives the way that it's supposed to thrive. If you have a strong and empowered engineer, you will always ensure that the decisions that come out, and I always say this, and I know people ridicule me for saying this, but I almost believe that the engineer is, say, for example, a court of first instance, where who can at least set out the questions of fact properly and can at least lay down, all right, this is what factually happened. Whether the principles of the claim can be debated and discussed and dissected at a later date using DABs, arbitration, and appeals, absolutely. But the facts remain the facts. And if you've got somebody who can truly set out the facts correctly, the engineer should be doing that. More often than not, like Gracious mentioned, and this is something particularly true for, say, Indian subcontinent, wherein the tender draftsman happens to be the person that is the engineer. Now, we all know that tenders always, and I'm just going to I'll go out there and make a blanket statement, always tend to have one goof up, if not more. And the fact is, if the engineer starts trying to protect himself by trying to protect the tender, you can never have a fair outcome. And this is where more often than not, we tend to lose out. There has to be a separation between the PMC and the engineer, or whoever is the agency that drafts the tender and the engineer. This will ensure that at least a fair perspective can be taken and that there isn't this constant sword hanging over the head of the engineer. The moment he says, okay, but this is something that the employer now needs to pay. The employer first says, if I pay, rest assured through my agreement with you, I will also be making a claim against you. And so you've got this sword hanging over the head of the engineer that because he's goofed up in the tender, the employer is now having to pay for it. And now the employer believes he's going to get it through one way or the other. The independence then gets completely knocked down. Segregation, first thing I think is very essential. The second thing that Gracious was speaking about is the quality of the determination. More often than not, a very lazy effort is made to actually put down. I mean, what the clause says is the approval of the principles of the claim, it can be summary, the approval. But the disapproval has to be with reasons. It isn't good enough to just say, all right, rejected, which more often than not is what you'll see, or at least I see as far as the practice of contractual claims is concerned, that the engineer at one point of time will just give you this really silly response, which is 1 page for 32 claims, rejecting every single one of them. It isn't the way that it was meant to be. You have to do an assessment. You have to look at the principles of the claim, decide why they don't apply. or if the principles apply, why no quantum is attracted. But this effort needs to be made till such time as truly professional services are not brought in. And I'm not saying that a high-end firm wouldn't be doing this, but I'm saying more often than not, you choose L1, whoever bid the lowest, and you get exactly what you paid for, even in the form of an engineer. And so that tends to be a problem, that you're saddled with somebody who may not have the necessary skill set to deliver for you. Eventually, the employer pays whatever would have been H1 price because he loses his claims and he ends up paying a lot more. But having the right agency do your work for you, having a separation of powers, having balance, equity between the two sides, I think that's very important. That's my say, at least.
Right. Unless the two of you have anything particular to say, I don't want to keep David hanging too long.
True.
So do you have some time, David? Like another 5 minutes, maybe?
I must. I've literally got that at 3:15. I really must go.
All right. So just another question regarding.
Can I just come back on that one a little bit?
Yeah, of course.
An anecdote, a true story. Back on a very early version of FIDIC, there used to be a clause in there called major economic dislocation.
Oh, that's right. Yes.
Yeah. And I worked on an arbitration where the currency of the country where the project was being built devalued twice. And it doubled the cost of everything imported. The engineer on the project used his favorite word, which was no. That is not a major economic dislocation. He was queried what was it, and he couldn't tell what one was. But it went to arbitration. And during the arbitration, it was suggested that you have to think of the commercial word of the engineer. This is going back some time, as you can imagine. This engineering firm was linked very closely with the funders. This engineering firm is a red book, did all the designs and everything such they could put the budget to the thing, they could put the time scale to the thing, and they had committed their reputation to the funders and more importantly to the funders and then the subsequent employer. And they valued that reputation more than fairness.
True.
They could go back to the funders and other funders and say, we delivered these projects on time and on budget. Fairness went out of the window, as with the major economic dislocation. They lost very heavily, obviously. But they have their commercial concerns, just as contractors have their commercial concerns to pursue something that may not be worth pursuing or concede because it's a commercial point or whatever.
You're both on the same theme, and I agree with you that the segregation of roles is just so important. And if you can achieve that, then there's a much better chance of getting properly neutral results. The trouble is persuading him, or for an employer to persuade itself that it's worth paying more, because it will be more to bring in somebody new, and our owners, employers prepared to face that. And then to get decisions which are going to go against them more often than they otherwise would. So it's easier said than done to achieve what we know would be the right thing.
Question for my co-panelist: have either of you experienced engineers being taken to court for damages because they got the budgets wrong, or threatened,
extensively threatened? But then more often than not, employers don't actually put the pedal to the metal, but they're definitely threatened multiple number of times.
Yeah, and I think I mean, there's insurance at work here. I think threatened a lot, and I'm aware of claims and settlements, and obviously insurers coming in to fund that. I've not actually been involved in a anything that's gone to a hearing like that, but certainly disputes and settlements.
Oh yeah, and the way I look at it is because these contracts are quite long term, especially if it's starting right from the start, from the stage of like preparing your tenders, all the way up to the defect notification periods. I mean, it's a very long term contract, and employers don't really want to like lose their existing consultants or like be in a sudden scuttle with them while the projects are going on in terms of the works projects. And it really helps. Actually, it's nice to keep threatening them, because ultimately when it comes to the end of the project, you can always have a certain leverage to negotiate. And that's what we sort of rely on. And when the consultant agreements are coming to an end, use that as leverage, see what kind of settlements can be drawn at the end of it.
So to bring this back to employers' claims, for an engineer to be overzealous with rejecting extension of time claims and then taking delay damages, and then perhaps being a little bit biased when it's in the employer's claims, if they exist, is just another way of balancing the books. I have my cynical hat on today.
Well, David, I think it's about time for you to leave. So
yeah,
thanks a lot for being here.
So much.
It's been an absolute pleasure as always, and I'm sorry I have to leave, but I
will pick your brain on another occasion. I mean, I do have some questions to ask you.
Okay, well, we're looking forward to seeing you in England in person. But thank you very much to everybody who's joined today. It's been a great pleasure, and
Take care.
I wish you well.
Take care,
Okay.
David.
Bye now.
Bye, David. Thank you.
So I suppose moving forward, we could take a quick break, maybe 5 minutes or so. That after that, Ranjit, you could take the lead.
Sure.
And then Paul, as usual, we'll hear from you, tying things down. Let's take a quick 5-minute break. Yeah.
1945 is the time I'm seeing now. 1950 is when I think we'll start. I'll set up and just a quick bio break, guys. Thank you.
Thank you.
Bye.
I think I can probably just get started. What do you think, Paul? Shall we go ahead or wait a minute for Gracious?
Oh, let's wait for Gracious.
Indeed.
He's the boss.
No, literally in my case, in some instances.
Yeah?
Yeah. He's worked as the employer side and I have worked for the engineer. So yes, the term he's the boss means a lot to me.
That will be good to see you when you come to UK.
No, I'd absolutely love to touch base with you, and I'm really looking forward to it. In fact, we'll send our itineraries across just so that we can plan your time, and then we can just drop
How long will you be here for?
I'm probably thinking about 2 days to network, so probably arrive a couple of at least there's a weekend right before, so I think it's from the 11th to the 15th of September, and then so probably I think Gracious is going to show up around the 5th. I'm thinking I'll probably show up midweek, say around Wednesday, a week before the actual event. So I'm thinking 6th, 7th, 8th probably would be something. 7th or 8th is when I'll show up. So I'll probably do a Wednesday, Thursday, Friday, trying to meet people. But yeah.
Oh, that'll be. Yeah. We do a lot of work with your company.
I'm aware. I'm well aware. In other jurisdictions, but yes, I'm well aware.
The Dutch office have been traditional trainers, I think. Yeah, but no. Let me know you're not going to be around on the 26th. You'll be back home by then. I take it.
Well, yeah, well and truly back home.
Yeah, it's a shame. We have a big party on the 26th.
Oh, my loss. Completely my loss.
A good venue in the Houses of Commons, in the Houses of Parliament.
Yeah, I'm really missing out then. That is saying something.
And they've stopped doing it, I think, for security reasons. We used to be able to get a tour around the two chambers, so the Commons and the Lords, but for security, I think they've stopped doing it now.
What a shame. It would be a fantastic experience. I would have probably just flown down just for the heck of it.
Yeah. But last year we had a different venue. We had it out on one of the balconies overlooking the Thames.
That must also been lovely.
Yeah. With an indoor backup in case it rained, but it didn't.
Oh yeah.
Where are you, Gracious?
Let me just give him a quick call.
Okay.
He's just coming. $67 for one. Oh wow.
a lead of 158. I didn't see the screen collapsed.
No, in the morning, I think it was 6 for 47, 6 wicket loss for 47 or something like this. It was a real collapse in the morning. But yeah, no, Australia are really bringing the pain.
Yeah. I was traveling on, driving all day on the final Monday, going on leave. And it was fascinating listening. I love Test Match Special. My wife does too. And we would just listen to that all the way. We had a 5-hour journey and we listened to it all the way. But it was fascinating listening, but it was so painful to be in such a commanding position and then just cannot get these guys out.
They did really well. You have to give it to them.
Yeah.
I think Gracious is calling.
I imagine these parts are not being recorded or edited, will be edited out of YouTube.
I think so. I'm hoping so, yeah. Yes. So I believe I'm audible. Yeah. Paul?
Sorry?
Am I audible?
Are you?
You can hear me, right?
Yeah, I can hear you. Yeah.
Perfect. So I think we'll start off. I just spoke to Gracious. I think we don't want to lose our audience that is sitting around. So we thank you guys, whoever's waited patiently. And our host will be joining us in a moment. But given that we'd like to stick to our timelines, I'll just start off. I want to be honest and reasonable. I don't think there is much new that I can truly add after what David has said. Maybe a couple of stories, maybe a couple of times about physical instances of what I may have seen. But the honest truth is, I'm not going to try and interpret the clause in detail or things like that. I don't think I could do a good job justice. I mean, David just did a fantastic job. And so I don't really want to water down what he said. So I want to, off the bat, start off by saying that this is an unenviable task. I mean, the employer's claim, particularly for me, even though I've been an engineer, it has personally brought me no joy. And I have always been at the receiving end of contractors' claims. And I just believe that sometimes contractors keep the engineers so busy that there is rarely a consultation between the employer and the engineer in context to what may be the employer's rights. And but I'm made to understand that this isn't always the case, that the contractors are not necessarily the ones that are strong arming the employer all the time. I believe in the Middle East, there is a regular set of instances wherein the employers are aggressively putting forth their claims. In fact, the level of organization as far as the Middle East is concerned for employers and their claims department, a specialized claims department for the employer, tends to be a lot more professional as far as the Middle East is concerned. And so this, I believe, may just be instances that I speak of which may apply to South Asia or the limited jurisdictions that I've worked in. But I will look to Paul to educate me at some point of time of what his experiences have been insofar as employers' claims are concerned, because I definitely haven't seen them successfully mounted or go through, so much so that I've had instances wherein one of the contractors specifically told me that, well, you can try, but can you please tell me of one instance when the employer has succeeded? And the honest truth is I didn't have an answer at that point of time. So it is a rarity for employers' claims to succeed. And if you are listening in on this and are part of the setup of the employer, then I do believe that I should have a few takeaways of why I believe we failed in the past and what we can do better. So what I'm hoping to do is, this is the structure that I'm hoping to go through. And the part where the fourth slide, where it tends to go wrong, that is the part where I intend to touch upon and basically share my experience of where I think we've gone wrong in the past and what I'd love to see become better. I'll be honest with you. Yes, I am the gameskeeper turned poacher, as was rightly pointed out to me. And I quite like that term and I'm going to keep it that way. But the truth is, isn't all money coming for public procurement, isn't all money coming for the state exchequer from our own money. And so effectively, everybody has got a duty to protect their own money. The taxes that we're spending eventually should result in better infrastructure and not necessarily cost claims. And so just to start off with the basics and the basis, right? So the basis and the basis, we've had an opportunity of hearing in detail. And so I'm not going to touch upon the clause itself in detail. But what I do want to talk about is the fact that the employer is more often than not the passive claimant, and that he's just sitting around and is just waiting for things to play out and doesn't necessarily play an active role. So much so that the contractors are very, very organized compared to the employer. And more often than not, at least in my personal opinion, I found that there are a lot of technically exceptional men of very, very sound wisdom as far as technical concepts are concerned. But unfortunately, that doesn't necessarily translate into great claims. Now, the reason why I say that is because I believe that mounting claims and successfully seeing them through is a different beast altogether, which is not to say that technical men cannot do it. Of course they can. Engineers are phenomenally good at mounting claims as well. But the truth is, there are certain nuances, there are certain things that you need to be aware of. And always the problem exists with the fact that once these claims go before an arbitral tribunal, then it takes on a whole new role in itself. So while you may have been operating within the four walls of a contract, successfully so, and you may have felt that you've done everything right, unfortunately, the considerations of whatever is the prevailing taste of law at that point of time, these need to be taken into consideration. And again, I will be speaking a little bit about those as well, particularly given the fact that this is SCL-India, how it tends to happen more so in our neck of the woods, and why I believe that we need to always remember that while it's great to have a FIDIC-based contract, the pragmatic considerations may be coming from somewhere else as well. Just like we were seeing a judgment of the Middle East or of the Caribbean, there is a plethora of judgments in India that may not necessarily be based upon FIDIC contracts, but do necessarily touch upon construction law and construction law interpretations thereof that are becoming more and more involved in as so far as this field is concerned. There are also instances of just case laws relating to arbitration, which have now come back, and these apply verbatim to something, say, for example, such as construction law and FIDIC in general. Now, I believe that anecdotes are necessary so that people don't lose their interest. I had the pleasure of speaking at a particular conference of a contractor, and the conversation or the debate that was ongoing was that, well, the claims department should be treated as a profit center. Now, it cracked me up. It really did. Because as I teach my 7-year-old some concepts of economics, because its cruelty runs rampant amongst us lawyers. And so I was teaching my son of what is profit. It is the sale of that which you bought for less. When you sell it for more, it's profit, correct? If you want to view cost claims, and I use the word cost claims very specifically, if you want to view cost claims under the head profit, then I believe that there may be an element of dishonesty. When you go and study negotiations, for example, you're generally taught this concept of ask for a super high number and then work your way down. Unfortunately, this tends to be the case even as far as claims are concerned. Everybody is mounting really high claims and then just hoping for it to trickle down to a number which may actually be realistic. I tend to find that to be discomforting. More often than not, you're faced with very, very high claims. And particularly if contracts departments are now being viewed as profit centers, and if they have internal targets, then it's getting a little scary for me. So I also believe that may be of importance as far as employees' claims are concerned, so that if done well and if done in time, it may be possible to offset the impact of these things. There's also this problem that there is always this unintentional bias against particularly government when it comes to arbitrations. And at least I speak for my jurisdiction in particular, there is always this unsaid bias that, oh, these guys always strong arm the contractor is at a place of disadvantage, the contractor is always at the receiving end, he's at the mercy. I tend to disagree. Yes, has it happened in the past? Do small contractors get strong armed by the government? Absolutely they do. Plus there's always this wonky drafting that you'll have. The employer's decision shall be final and binding. I mean, jokes like that continue to exist in contracts and they're quite prevalent and you can have a laugh about them. But the honest truth is there is this unintentional bias, and more and more judgments that are coming out, you tend to see have this bashing of the employer, and it's not setting a good precedent, because you will definitely see a lot of contractors' claims and a lot of law that follows contractors' claims, very detailed, very articulate arguments being put up. But that necessarily isn't the case. It's more often than not bashing as far as the employer is concerned. Some of the clauses that I found that are quite interesting are things such as, like I mentioned, the decision of the employer will be final and binding. That's one of the jokes that you'll often see. Then another thing that you tend to see is that prior consent of the employer shall be required before making an extension of time or a cost determination, right? So specific powers of the engineer are watered down primarily because there is this over-engagement as far as the employer is concerned. And the drafting, even though initially it is believed to be of great value, eventually doesn't hold good. I mean, so much so that now, in a recent Indian case law, it was held that a no-due certificate, post-completion, when you give a no-due certificate, saying that, okay, I no more have any claims against you. The courts have even gone so far as to hold, in India at least, that even this no-due certificate may be issued under duress. And so therefore, you can't hold it against the contractor. And that even post-granting a no-due certificate, the contractor can revisit his claims and can rake the old story up again. Now, this really complicates things. So as far as the employer is concerned, there is no true closure then, even if you've got a no-due certificate, because the courts are holding it otherwise. Now, again, like I mentioned, there is an overwhelming precedent so far as successful mounting of claims of contractors is concerned, and not so much when it comes to the employer. And so therefore, it is quite a difficult task in question that you're dealing with. Now, just to quickly touch upon something, and I really wanted to ask you as well, all three of us, I mean, in fact, I would love to ask all of you guys as well, that the words used in 2.5, and I'm reading from the 99 edition, is as soon as practicable. And then whereas the contractor, it says within 28 days. Now, everybody tends to think that, oh, as soon as practicable allows for more leeway. In my mind, I believe it is more stringent than the 28 days, because in at least you have 28 days from when the incident occurred or when you ought to have known. But in this case, as soon as practicable, for me, makes it so much more stringent. While you knew, or how does one interpret the words as soon as practicable? And I would have loved to pick both of your heads on it, and I will leave that as open-ended. I don't know the answer. The honest truth
in fact, I do have this posted as a question on my notes. This is something that I wanted to even check with David as well.
Sorry to steal your thunder.
But let's wait till you finish, because we will sort of discuss that, and maybe Paul will have a few thoughts.
And because in my mind, which is more stringent? Is it the 28 days or is it as soon as practicable? And what does that even mean? The honest truth is, what does that even mean? And I understand that it's kept open-ended. Yes, it's vague. It allows for the employer to bring back his claims. Yes, we understand that it isn't intended for the employer to be belligerent so that relationships break down. And all of that, I understand all of those pragmatic considerations. But for me, in my books, it actually feels stronger than actually 28 days. Now, another fun thing is, if you see the last para of 2.5, it uses the word may, right? So, sorry, in 14.3, any other additions or deductions which may have become due. Now, this for me throws up an interesting question. Well, either it's due or it isn't due. May have become due. How is it that the engineer is now coming up with this? And I've been thinking about it. And the only reasonable explanation that I can find in my mind for 14.3F, having the word may, is the word cost says actually incurred or likely to be incurred. So I'm presuming that if there is something that is likely to be incurred and that is presented as a claim, then that probably can be included under the category of may become due under the contract. And I'm thinking that may be the only way that can be included. But to my mind, it throws up a very big question. Either something is applicable or it isn't. But the word may attract something from the definition of costs, I'm thinking. Another thing that I definitely think is very, very fun to read is the word payments is used. If you believe you're entitled to payments, while the word cost is defined, then in some clauses it says cost plus profit. In particularly in the claims clauses, and I'm speaking for the 99 edition in particular, the word payment is used. And I find that very nice and open-ended. Of course, like David said, it speaks about damages for breach. It speaks about costs. It does cover a whole plethora of things that come in, but the word payment, which is not defined, does provide a nice little leeway to throw in pretty much the kitchen sink, right? I'll move forward. And again, because so much has already been said, I'm going to try and skim through, try and be as quick as possible, because I don't believe that there is a lot of novelty that I can bring to this. But this has already been touched upon by David, so I'll probably just quickly skip through it. What can you reasonably hope for as an employer's claim? And again, this is a mix of everything, 99 and the latest edition. Employers' facilities and free issue material. I really think, and if some of you are on the consultant side, what tends to happen is that the employer, out of the goodness of his heart, will give a lot of things. Oh, use my office, use this, use that. I have an excavator sticking around, please use it. But the moment things go sour, that's when they start putting a cost on it. And this is the unfortunate part. You can't wake up. And the problem with most of the employers' claims are that they are an afterthought. Rest assured, they are more often than not, they're an afterthought. Only when things go sour or when things go out of hand does the employer decide to strong arm. And this is one of those problems. If you're issuing certain things, please include terms and conditions in detail with quantum of what you intend to get against it. Because if not, you're probably giving up something for free. And subsequently trying to put a price on it when things go sour is not a good look for the employer. Then the next is failure to carry out remedial work and repetitive effort due to the cause of action. Again, like abatement, already spoken about. And there are instances, say for example, it's quite fun that the contractor may notice that there is a crack in a particular thing and he says, I'm not going to remediate. Now, more often than not, contractors will do it. But when the nature of the damage or the nature of remedial work required is actually going to lead to admission of defective work or admission of poor quality of works, that is when contractors try to get really, really intelligent and they try and limit their liability. These are the instances in which the employer needs to be aggressive, needs to come out and say, so for example, if there is a two-tier pier, right? I'm just speaking about marine works because that is something that I've extensively handled. If there is a two-tier pier and the lower level of the pier is expected to handle weapons, which may or may not have nuclear payloads, and also very, very expensive electrical equipment, there cannot be leaks. Water can't be gushing through. But the truth is, it may be eventually you may say that this is not fit for purpose kind of work, but eventually you do expect remedial work to be carried out. Contractors may power grout, may do whatever, but it still may not be good enough and there may still be seepage of some level. Sometimes they just refuse to carry out remedial work or they gloss over the problem. So these are the things against which employers can take up. And this is in the normal course of actions, right? Delay damages, everybody is well aware. Another misnomer, problem particularly within my jurisdiction that I find is people tend to believe liquidated damages and delay damages are the same thing. And I just believe that we need to stick to the language that we've received. The delay damages is quite clear in its outlook. The words have meaning. They are not liquidated damages. The one is not a substitute or a synonym for the other. And we should not try and substitute one for the other. So again, delay damages, it's something that you can get as an employer. The last part is the part that I tend to find is the most difficult to establish, that something is not fit for you, the purpose that it was at. Say, for example, if you want a solar plant to be set up and you expect that it is going to generate a particular number of megawatts and it falls short. Now, this is the problem. As lawyers, your lawyer will tell you, well, if the price is A and this is the number of megawatts that was expected to come out, well, then just equate it for whatever is the final result after tests and completion. And whatever the shortfall, that is the amount you may be. That's an oversimplification. The contractor's lawyer will say, whatever we've spent is costs, right? If we can document our costs, we can probably say, look, we've done what needed to be done, but we've fallen short. Maybe a small amount in damages may be paid. This is the gray area that comes in. And it becomes extensively difficult, right? And again, I speak purely for my jurisdiction because we don't have specialized courts when construction law or technology courts exist. More often than not, we will choose from a set of arbitrators who are generally old retired high court judges or Supreme Court judges. And these men then need to be extensively educated on technical parameters. And it takes months. And you can have a very, very basic question being propped up right at the time of final arguments, which is very, very disheartening as far as I'm concerned. Because you've been putting up this show, song and dance for the last 6 months. And they ask you simple questions like, say, for example, oh, well, what is the difference between a cutter section dredger and a TSHD? So the truth is,
I've been asked at the end of the final arguments, are we supposed to be dealing with all delays or just the critical delays?
Lovely.
What are critical delays again?
Exactly. And again, this isn't a critical appreciation, or this isn't a ranting session. What I'm just trying to say is this is a practical problem that we have to overcome, because there is a lack. Now, I believe that as of yesterday, the Supreme Court has decided in India to give rosters based on the specializations that the judges profess. And I think that's brilliant, because that is proactive thinking. That is at least putting the right matter before the right person. Similarly, as far as arbitrations are concerned, we need to definitely move away from only using High Court judges or Supreme Court judges, and we need to move towards getting men and women who are technically competent and yet know how to handle an arbitration, just because the nature of questions that are posed are highly complex and the costs that are involved are highly prohibitive. And so a right balance between the two is necessary. So what can you reasonably hope for? These things, of course, breach of contract, damages, penalties, all of those exist as well. Now, before I move on to this, I'll tell you a couple of times when I've had employers' claims mounted, and the proximity to the actual contract is so little that you tend to ask yourself, what were you thinking? A question was asked earlier about, well, how can the engineer operate independently? And I believe that if law firms can set up Chinese walls, so can engineering firms. And I don't think it should be too difficult. The person that mounts the claim shouldn't necessarily be the one that determines the claim, if you're doing it on behalf of the employer. I think that's a simple starter. In addition to that, what I also believe is that it is possible for objective reviews to be carried out, so long as people pay attention to the details, right? It is possible to do an objective review. But coming back to my main question, the problem with employers' claims is they're more often than not an afterthought. More often than not, they tend to be over-exaggerated. The basic effort is, if the contractor has claimed X, I must come as close to X as is possible so that I don't look weak. And the honest truth is, it shouldn't work like that. You're just by propping up claims, all you're doing is increasing the arbitration fees. That's what I believe. Because generally an arbitrator will consider the cost of the claim and the counterclaim. But all you're doing is increasing your own pain. If you have a reasonable claim, if you've thought it through, these should show up. Proximity to the contract should exist. Airy-fairy employers' claims tend to do more harm than anything else. And you're not treated with the same level of respect or sincerity as you would if you did a thorough job at it. And so I just believe that rather than being overzealous as far as the employer is concerned, really measured claims are what is the need of the hour. Now, as far as the engineer is concerned, and I just want to briefly touch upon it. Yes, the first expectation and reality is the truth. More often than not, you will have the engineer being completely bogged down. I've recently been privy to a case in which the engineer, rather than determining, would make a recommendation. And the words used would be, it is recommended that the contractor should be paid. And then the employer writes back saying, I'm not paying. And then finally, at the end of the contract, the engineer writes a large determination in which he has rejected everything, having recommended something earlier, but then eventually, because his final bills were required to be settled because the contract was coming to an end, he's given a determination saying, no, nothing's payable to the contractor, goodbye. And so the truth is, things like that are not a good look. Engineers need to value themselves, need to realize that by being unbiased, by being balanced, by acting in a timely manner, things will go well. And I believe that timely manner is very important, because the problem is we do a lot of wait and watch. There's a lot of retrospective action. Claims are not dealt with prospectively. So the need of the hour may be, while dealing with an employee's claims as well, have a proactive approach. While dealing with the contractor's claims as well, do it in a timely manner, right? And the most significant thing that I believe, again, I've already mentioned this, is that the engineer can provide an unbiased and possibly an unchallengeable version of the truth that going forward, all forms of dispute resolution will lay reliance upon, provided that you make the effort. So if there are narratives that you disagree with as the engineer, I think it is your duty to correct those narratives, even if it means amending a DSR or a daily dredging report, right? Where it tends to go wrong. Now, in case you've noticed, the contractor bases his claims upon a daily site record. These are generally included as a part of the contractual submittals or transmittals. And so he submits a DSR And the DSR is signed off by the engineer. So effectively, you've agreed to this factual narrative that exists on record for all to see. And unless and until you made an effort to correct the narrative. So if there is something wrong with the narrative, if there are certain equipments that are lying idle and not because the employer hasn't provided site, but because there is a lack of fuel, or because there are work fronts available, but the contractor simply doesn't have the required manpower, then these narratives need to be corrected. If you're going to mount an employer's claim, you can't be mounting on the base of DSRs, right? The daily site records can't be your basis for mounting a claim which is diametrically opposite to that which is being stated as a factual account of things that occurred. The next thing is, these claims, the employer's claims, should not be a knee-jerk reaction. I found this to be too often the case, that once you have irritated the employer enough for the employer's threshold to be breached, he will then start asking for, well, where are my claims? It cannot be the case. Either you have a claim in a timely manner or you don't. It cannot be that you do this in a knee-jerk kind of a reaction manner. Failure to follow procedure under 3.5. The problem is, because the employer can exert a lot of control over the engineer, there is this tendency to not even identify clauses under which relief is sought. This is the set of accounts that has happened. This is the cost. What clauses are attracted? Why do you believe it is either under the clauses of the contract or in connection with this contract? What is the proximity of the event to the contract if it is in connection with the contract? If you have a claim, it cannot be that because of X, Y happened and Y would not have happened had you not done this, but because of Y, Z happened and the cost of Z is this. It becomes really difficult to demonstrate clearly when there is a lack of proximity, right? So for example, I had an employer's claim wherein the employer stated that because certain facilities were not available, he was not able to bring in a large vessel, which is required for the armed forces. Because that vessel could not be brought, the staff that is required to be brought along with it did not move to the base. And the base already had homes ready in it, which means that the cost of the rent of those homes has been wasted. And therefore, this is my claim. It became so difficult to establish the proximity of, well, who's responsible? What happened? Were these homes truly ready? Would the staff have moved in? And whether the delay is attributable to the contractor. These are all very, very difficult questions. But the employer is completely convinced in his mind that he has truly mounted the contractor and that he's got him by the scruff of the neck. Unfortunately, I don't think these things stand. Now, recently in India, there is this new scheme that has come up wherein the government is actively, earlier, amicable settlements was seen as basically people shaking hands under the table. And it was something that was generally dissuaded under public procurement policy. Recently, there is a policy that is coming wherein the government is saying, well, let's try and move forward. Let's try and settle. Let's try and put things in the right place. It's called Vivad se Vishwas, which basically means from dispute to trust, the transition. And what it says is that claims plus counterclaims should be taken into consideration. And what this is going to mean is that more often than not, the quality of the claim or the counterclaim isn't required to be considered because it simply needs to be mounted, and then conciliation or mediation can happen based on that and settlements can take place. This may lead to exaggeration on both ends, the employer's end as well as the contractor. And I tend to believe that being realistic and being real may be a better course of action because you don't have to necessarily settle. But when you go for arbitration, you don't wish to be ridiculed. Now, the last thing is that I've often found is because the contractor, because the employer controls the engineer, they simply ask for deductions to be made in the next bill. And this, I believe, sometimes is the reason why there is a bias as far as arbitrators are concerned, because they see high-handedness. And this is often coupled with the fact that DABs are completely deleted. So it's basically the engineer decides and then you immediately go for arbitration. It isn't a healthy system. So if any draftsmen are listening in on this, I would genuinely recommend you to use DABs. No matter what you think of them, and we don't have a very high opinion of DABs, but all I'm saying is at least it is one more forum wherein you can have the principles tested, wherein you went through the fair process. By deleting DABs, you add no value. Arbitrations are prohibitively expensive. For small claims, they can be as large as 10%. For large claims, they can be as low as 1.5%. All I'm saying is that the cost of arbitration is exceptionally high. The intermediate steps that exist within FIDIC contracts shouldn't necessarily be deleted. Now, the next thing is, what can you do better? I'm just going to breeze through this, hire better resources just to mount and defend. Stop skimming on the costs. L1 is not always the best. If Taj Mahal was built on L1, it wouldn't be a wonder of the world, right? You need to spend money to get better resources. Getting better resources will help ensure you mount a better claim. Regular correspondences, even on progress. The engineers tend to write simply when responding. Initiating conversation, initiating communication should also happen from the end of the engineer. And I don't believe that you simply need to volley. You may also serve sometimes, right? Strict adherence to contractual timelines. I genuinely believe that what is worth doing is worth doing well. Now, again, just as a side note, within India, this is something that is very, very prevalent, at least, that if the Contract Act provides for a timeline, particularly in context to limitation, which is 3 years from the cause of action, more often than not, arbitrators are convinced that if there is a shorter timeline, say, for example, 28 days or as soon as practicable, according to FIDIC, these would not apply. So the 3-year timeline continues to exist, but I still believe that if you seek equity, you must come with clean hands. You must do it well. And so therefore, I do believe that strict adherence to timelines, whether convenient or otherwise, just because you have a backup in the form of the law, shouldn't be something that is laid reliance upon naturally. Do everything within the contract, within its 4 walls well, and this will demonstrate your bona fide when it comes to arbitration. Whether or not it stands is completely immaterial, but at least your bona fide of the fact that you did well is demonstrated. Then clear and detailed determinations. I believe this is very important, not only on the principles of the claim, but also quantum. And if you're rejecting, be triply sure, because it is going to be challenged at some point of time. We've already discussed separation of powers between the engineer and the draftsman, and detailed particulars of claim. There are several quantum specialists that now exist. It isn't good enough to come up with large numbers that are unsubstantiated. Doing a good job is important. Of course, recently, again, coming back to the Indian context, there has recently been a judgment by the Supreme Court in which it is said that the notice doesn't need to contain all the details of the claim. And so as far as my jurisdiction is concerned, the notice just needs to be a notice of arbitration, and a statement of claim, which is detailed, can follow afterwards. But again, anything worth doing is worth doing well. So please be detailed. If you've already done the exercise when mounting your claim, I don't think it should be a difficult task converting that into a statement of claim when you finally go for an arbitration. And the last thing is, and this I always find to be a problem, engineers tend to wait and watch. It isn't fair if the contractor is suffering simply because you're holding on and you're waiting for a new delay event to come, and then you want to club the two together. Everything should be done within the right time frame. And the more you do it within the right time frame, the contract and its spirit will go forward. Parties tend to have less problems when things are sorted within a time frame, right? Now, I'm going to close with a concluding remark. I would love to see more quality insofar as the employer's claims are concerned, because I genuinely believe in India, the Statistical Department of India says that 66% of all mega projects, a mega project is defined as anything that has a value of more than 100 crore. 66%, and this is pre-COVID, so COVID has nothing to do with this. 66% of all projects are running behind time. And about the remaining 33%, they don't say whether it was completed in the extended time for completion or what was the case. But 66%, so 2 out of 3 projects having a value of more than 100 crores will necessarily fail. Employers' claims have to exist if discipline is to be brought into the entire industry. This is the need of the hour. Contractors are having a free hand. They're mounting claims. They're making money, even though they're not delivering, which I'm not saying the Statistical Department of India is saying. There may be multiple reasons why these projects are delayed. But all I'm trying to say is projects are invariably delayed. And yet employers are not being able to do, or are not being able to get their money, or are not being able to come down heavy on the contractors. So the employers need to do better. This session, I'm sure there'll be like 20 people that will be deeply interested in this session, because there are so few people who are interested in employers' claims. But I believe it is important to bring about equity, to bring everything to parity. And going forward, what we really need is for better claims to be mounted and things to become more balanced. We need a middle ground. The employer needs to be protected. Engineers need to do better because the need is now. And again, I believe this will bring about discipline, which will in the long run bring about better results. That's my personal opinion. I think I'll stop on that, Gracious. I've said my piece and I've exactly done, I think, 29 minutes. So I think I'm good.
Thanks, Ranjit, for, I think you were able to sort of infuse a lot of practicality from your perspective and sort of going back to, what the reality is of how the Indian conditions are. And I suppose that there might be elements of these reflecting in other jurisdictions as well. I kept seeing Paul smiling every now and then. So I'm guessing that a lot of things struck a chord here and there. So I'm wondering now, because it's already 8:30 over here, and it's with just 3 speakers. I'm always surprised how we sort of lose time. Paul, I just want to know, like, how long would your presentation be? Because we can maybe have a couple of questions discussed now, and then we move to you, or how would you like to do it?
I can be very quick because I'm wrapping up. I'll be quick. I'll just pick up on a couple of things that Ranjit said. Right. And I think it was a superb presentation. I think that to all of those who are listening live or YouTubing later on or whatever, so much has been said about the individual clauses, which is very the rose-tinted glasses view. This is what the clause is intended to say, whatever. One, we all know that most contracts are amended, but Ranjit's put a very practical spin on it. And I think, we've got to realize that we do work in a commercial world, and practicalities come and bite us at all times, whether it's the inflation of claims or whatever. So, and the other thing I picked up on, Ranjit, was jurisdictional influences. Different countries, different regimes, different politics, different religions influence the way we work in our contracts. Right. One other thing that I picked up on, you said about the use of dispute boards. There are now statistics coming out that when the avoidance facility is used, more projects run to budget and run to time.
Really?
Really. I was with a lot of people from the DRBF earlier on in this week, and they're now saying that is now fact.
Wow.
But then again, I was with one of the past chairs of the DRBF or presidents of the DRBF, and she said that it's a shame that FIDIC had to use the word avoidance in the 2017 because the mechanism was always there with the regular visits.
Oh yeah, of course.
Yeah. So that's just picking up on some thoughts that you said. I will be very quick with my presentation.
Right, and after that, we can sort of, wrap it up with a couple of questions that I have from Ranjit's presentation, where I can pick both of your minds.
Yeah.
Right.
So I'll take my screen, and hopefully I can find my presentation as well. Okay, I think this is the right one. Okay, we're there. I think everyone hopefully can see that. Good afternoon, good evening, wherever you are. Employers' claims. I will be quick because I think I said when we first discussed this topic, well, it's not going to be as interesting as long as the contractors' claims. And Ranjit said it's the unicorn claim. So I'm going to try and give it a little bit of focus. I'm trying to give you some reference points for later on. So moving on, we've talked about, some of you may have listened to me last time when I talked about contractors' claims. There, in my view, should not be a difference to the way they're administered, the way they're treated, or whatever. FIDIC is very open, very unclear in lots of things that if you look at the contractors' claims clauses that are equivalent, they're silent for the employer's claims. And I'll come on to that a bit later. So we've said already that the vast majority of claims on a project are by the contractor, and we've said already that requirements differ in the FIDIC 1999. But I'm going to say, should there be a difference? Those of you that saw me talk on contractors' claims would have seen my 3 hurdles. The 3-hurdle race, fall one of them and you're out. You have to have the entitlement under the contract or law. That's the word or otherwise in the clause. That's a claim under the law. So it's compliance with it and compliance with the contract in terms of notices. That we've done to death, I think. We've also mentioned that there's got to be a fact-based demonstration of the events, the merits of the clause, the merits of the claim. And then later on, we've got to establish the actual effect of the events, the cause and effect, to give the damages side of it. I think the employers have got it very easy, or the engineers have got it very easy when we talk of delay damages, because to me, it's black and white. The contractor has an extension of time, or he does not have an extension of time. There's no great judgment to be made. You get to the time for completion. It may get a little bit grey if there are outstanding requests for extensions of time, and no doubt there will be. But this is where we will get the employer bias engineer who will say, no, and I'm going to take delay damages, and then you have the disputes work on from there. But generally speaking, we're talking about the money side when we're looking at the employer's claims. So just a little look again at the clause. And I'm going to pick up on one or two words that have not been mentioned. Any payment. For the contractors, we have the word cost defined. We have cost, meaning you've got to incur the cost and you've got to demonstrate the cost. And then you may or may not get profit. You will get your overhead. But what does it mean by payment? Does it mean cost? Does it mean that the employer is entitled to put an overhead on this? Does it mean the employer is entitled to put a profit on it? It's very unclear. It's very, very unclear. So have that in your back of your mind. That's one of the questions perhaps we can throw around and discuss at the end of the time. And I will rush through these. So what I've done, I did a little bit of a word search on FIDIC 1999. And these are all the clauses where we have the word under subclause 2.5. So obviously the performance security. If monies are not deducted from the from the contractor for the payments due to the employer somewhere else, the end result is to call upon the performance security, which is rather a draconian sort of thing, but the employer is king. Who drafted the contract? Who proffered the contract? The employer. The employer will get what it wants, whether the contractor likes it or not. And if the contractor doesn't like it, then you have to go to dispute. Electricity, water, and gas. Very often, as we know, that in contracts, the employer is the best person to supply these utilities to the contractor. So the contractor should pay for them. Maybe, as Ranjit suggested, there's some other bits and bobs that we do for nothing. And then at the end of the day, well, we've started to expend more money than we thought. The budgets are getting a bit wonky, so let's take those. It might be the knee-jerk or the afterthoughts. But normally the electricity, water, and gas is secure. Then again, going on to Ranjit's point, equipment and free issue materials. Free issue materials are free issue materials, but employers' equipment, can I borrow your forklift? I see that's sitting there doing nothing. I can save a bit of time if I borrow your forklift. Will we get a cost claim come? Will you not get a cost claim come? Moving on to more the performance of the works. Rejection and retesting. The engineer says, I am not taking this over. Therefore, you've got to retest. I'm talking a yellow book here. Therefore, you've got to retest. So then, well, what's happening? Well, the engineer, maybe an engineer flying in from another country, has to revisit the site. So the employer is fairly entitled to claim for that cost, that damage, that loss, that a payment. We don't know what payment is, but entitled to claim for that engineer's cost of retesting. However many engineers are there, whatever. It may extend to, well, I wouldn't have expended that electricity or that gas or that feedstock. You know, if you're building a brewery, then there's going to be more malt, more yeast, more whatever else goes into the recipe. I would have expended that had I not had to retest. So it goes on a little bit longer. Remedial work. We touched on this on a little while ago. If the contractor does not carry out the remedial work that's necessary to complete the works or get it to the standard that's required, Then if the employer carries that out, he will charge back to the contractor. Okay. Rate of progress. We all are aware that the engineer, if he decides that the rate of progress is not quick enough to meet the time for completion, can ask the contractor to put in more resources, have a recovery plan, call it what you like, but basically accelerate at your cost, contractor. There is no reason for you to be delayed, therefore please accelerate. So if that acceleration requires night working, requires 3 shifts a day, where the original hours that were defined for work in the project were, let's say, 8 till 6, now we're doing 3 shifts of 8 hours a day, then, well, the engineer's got to have more resources. He's got to fly those resources in from another place. He's got to rent more accommodation. He may have to rent more cars or whatever. Why should the employer pay for this? So there's another way where the employer can deduct money, can make claims for costs against the contractor. Delay damages, I don't think I need to say anything. I've said it before. It's the black and white claim. For me, I'm quite cynical. You have or you have not an extension of time. Now we get to the abatement section, if you like, failure to pass tests on completion. I worked on a project where we were to deliver a wind tunnel for testing Formula One cars. That wind tunnel was due to be pressurized, because if there's any scientists in the audience, you'll know that a pressurized wind tunnel can give more accurate Reynolds numbers than a non-pressurized tunnel. But it has to be very, very secure to hold air at 2 bar. It didn't. And it couldn't because there was some issues with welding. So we had to deduct monies. I agreed with the Formula One team back in the day was Benetton. Was involved in reducing the contract price because of our failure to meet what was required. And technically it was impossible, but there we go, it's another story. So a reduction in the contract price, an abatement. And again, here we have extension of the defects notification period. The additional time that somebody is going to be spending there because the engineer looking, checking, whatever. It's just simple costs. As most of these ones are simple costs. Again, another issue of failure to remedy defects, another issue of retesting, the costs due to retesting. And then we got the payments after a termination. The employer has terminated the contract, and then you got what happens to the employer to get those works to be completed. It employs another contractor. That other contractor is saying, well, I'm not going to do this work for the same price as the existing contractor. I want an enhancement. I want to use time and materials or whatever. But it costs the employer more to finish that project off than it would have done had he had the original contractor. And that is a claim against the contractor following a termination for default. Okay, insurances. Very boring subject, insurances. The general requirements for insurances, payments of the amount by the insurance party. If there's a claim that the employer has to take away from the contractor, it has the facility to do this. And then again, it's credit for insurances that are not provided by the contractor when the contractor is due to provide those insurances. This is just a little bit of reference points for those that want like little charts and one thing or another to look at it another day. I did another couple of word searches, and this is just a selection of some of the clauses. The word searches I used were hold harmless, which I think every time you see hold harmless in the contract, you think to yourself, I'm a contractor's man. I really am a contractor's man. Every time I see that, my antennae go up and I say, hey, the employer can make a claim against us because we're holding harmless. So this is just a few of them. Again, some repetition here, I'm afraid. Hold on. Do you know what I've done? I've snipped in the wrong one there. I'm going to have to read this off to you. I made some adjustments this morning. and I'm going to have to read off my own slides. I will adjust my slides and send you a new link. But in this one, I would have 8.3. This is not a hold harmless one. This is one I've just thrown in. Under 8.3, the program. The employer is entitled to rely upon the clause 8.3 program. What does this mean? The employer, when ordering all of those, go back to my brewery, when ordering fresh yeast for the brewery, fresh malt, he can rely upon the program. And if that program is then so far out that maybe that malt is no longer useful, he has to buy new malt, he can make a claim. He can rely upon that program when arranging for connections to services, the final power to the power plant, if you like, bad example perhaps, the water to the water treatment, the dirty water to the water treatment, or whatever. The employer can rely upon those those facilities. Anything the contractor has said in the program. Hold harmless and other items where you can imagine that there could be a claim. Safety procedures, clause 4.8, where if the contractor fails to comply with health and safety and somebody is injured, there is going to be claims. The contractor will hold harmless. Avoidance of interference. There's a whole raft of things where the employer and the contractor have an interface with the public, more so the contractor. Interference with roads, interference with the highway, dirty roads, damaging bridges when they were transporting equipment and so on. So you've got, my copy is very small, I can't hardly read it. You've got 4.14, 4.18, transport of goods, 4.23, contractors' operations on site, and that is maintaining a cleaning team after completion. The contractor did not clean the works, therefore the employer had to clean the works up for the contractor. Even in FIDIC, there's clause 6.11, disorderly behavior. If the contractor's personnel are going out and getting drunk every night and creating problems in the local, smashing up the bar or whatever, then that claim is not going to come back necessarily to the contractor, but it will probably come back to the employer. If it does come back to the employer, then the contractor will be charged with the mechanism. Indemnities to property and people, clause 17.1. Intellectual property, there's a breach somewhere. That is another way where the contractor can suffer by a claim. And then going on, there's obviously the fundamentals of the obligations of the contractor. If you look at the general obligations of the contractor in clause 5.1, then you have the fit for purpose, the design, the time, and the scope will all be done at the same time. So that's, if you like, my expansion of all the clauses, or some of the clauses, and I do apologize for getting the wrong snip there. The expansion of clauses where there is the entitlement, and I would love that word entitlement. It's used at the beginning of the clause. It must be something where you're entitled. So now we have, why not the same as the contractor? The contractor has to make a factual document to persuade, after discovering the entitlement, to persuade somebody, before we get to the quantum, that my claim is worthy. I've got to tell you the story. So why hasn't the employer got to have the same burden of proof on this? And then finally, the third part of the hurdle race, the evaluation and collection. Again, we've all touched on this a little bit before. Ranjit mentioned records. Why shouldn't the employer have to have the same burden of proof regarding records? The engineer might just say, oh yeah, here's a piece of paper that said it happened, but there's no story about when the people smashed up the bar, who the people were. It was just, oh, we received a bill from the bar saying there's damage caused, we want you to pay for it. Why shouldn't the employer have to have the same burden of proof? And I put in that slide I used for the, or a slightly amended slide I used for the contractor's claim. We need records because he in a dispute, he who asserts must prove. And I don't see why proving the employer's case to a decision maker, the engineer, when he goes back to being neutral and not the agent of the employer, the contractor, if he's going to accept the claim under the discussions we mentioned in 3.5, or if it has to go beyond the decision makers at a DAB or an arbitral tribunal or a court, why would they not be asked to look at the same burden of proof that a contractor has that should apply also to the employer? And a phrase that you heard me before, putting the other side in a position where they can't afford to say no. If the records are good and the 3 hurdles are achieved, then the other side will not take it to a DAB. They will not take it anywhere else for a formal dispute. So, briefly, and I hope I've gone quick enough, the collection of cash, and I put aside again delay damages because that's black and white. We have the first easy limb, the agreement under subclause 3.5 between the employer and the contractor, with the engineer allegedly acting as some sort of mediator. But now we've got the engineer saying, I'm going to mediate on my own claim. So of course I'm going to lead towards the employer. If they can't agree, then we have the determination under 3.5. Then we have, following the determination, the first opportunity, the adjustment of the interim payment certificates under subclause 14.3F. So if there's money due to the contractor, it can be reduced. And if there's no money could due to the contractor ever again, then it will be a call on the performance bond. Again, as I say, a little bit draconian, but it's there. And I wonder how much if there's a limit before you would call on the bond. And then going on, it may be a DAB decision or an arbitral award. But then we're getting towards where I've done my cartoon slide, ready for the first lessons into conflict resolution. And that was maybe one for next time. But I've rushed through that, and I do apologize for the wrong snip. But final thing, a case study, a real life one that is not covered anywhere in FIDIC, but it worked. An employer's counterclaim at arbitration. Contractor suspends the work, citing subclause 2.4. Might start to be familiar. The contractor terminates under subclause 16.2a. Obviously, the employer did not satisfy the contractor about his financial arrangements. The contractor commences arbitration. The termination is held as valid. The contractor was not quite so wise. There's the obligation to take care of the works until completion. The contractor took the mindset that because I've suspended because of a default, alleged default at that time of the employer, I don't have to take care of the works. So when we got to the stage of termination and then the arbitration, the employer had looked at the equipment that had been delivered to site. The project was a hospital, and there was container after container of control panels, electrical panels, switch panels, and the containers were just left in the tropics, sometimes with the doors open, sometimes they had been vandalized for pieces, but they were carefully checked at the time of the termination by the engineer. So this equipment was no longer fit for payment. So the employer at the arbitration went for abatement on the value. And as we've seen, because it is the same case, the contractor lost, the employer succeeded with the abatement, and that was held up in the Privy Council. I know this case very well because I was actually appointed by the parties an expert to value the works at the point of termination. So I was involved in looking at these defective materials at the project in Tobago. The country is Trinidad and Tobago, but the hospital was in Tobago. And so first-hand knowledge on that. And with that, I will say thank you. I've rushed it through so we can have some more good chat time. I've really enjoyed the chat time today. Thank you.
One of my favorite things that you said was about this disorderly conduct. And I never would have thought that the employer should actually turn that around, because we always have disorderly conduct. There is some labor colony which breaks into a fight within itself, destroys a television, does whatever. But what struck my mind is just sending the engineer to go see that labor colony and the cost associated with it. It may be the contractor's colony, he has to make good everything. But the fact that I had to send an engineer just to go and see the site is probably a cost that can be passed on to the contractor, now having listened to what you've said. And I think it just opens up a world of, it definitely has opened up my mind, at least, as to how I've been restrictive. I won't lie to you. Wherever I've seen employers claim, that's what I've stuck myself to. And now when I think about it, the possibilities truly are endless. Indeed. And I love the last example that you gave about how, in spite of having not had the funds, the employers still managed to come out on top. I think that's a brilliant case of hiring the right expert witnesses, wink, wink, and getting the...
Oh, we've lost him.
Yeah, I think there was electricity.
Well, actually, there were no expert witnesses, wink, wink. There was one expert witness. It was a parties joint expert. And if David had been here, the case was against a contractor against the department of the Trinidad and Tobago government. And the contractor made some very spurious claims, my opinion, with a little bit of knowledge. And the employer was asked at numerous times, can you pay the final account sum, which will include the spurious claims? One claim was $70,000 for loss of reputation, one line. That's how spurious the claims were. And the government got a little bit tired of receiving these 2-4 requests and then didn't pay enough attention to them. And the judgment noted that whilst it may be obvious that an employer has the funds, as a government would have, it still has to comply with 2-4 and say those funds are allocated for this project or whatever, or demonstrate notes of a cabinet meeting or whatever to say Scarborough Hospital has allocated to its budget $300,000 or whatever it might be. $300 million. Sorry.
Was that not easy enough to show?
The government could have shown it,
right?
But I think in reality, and this is my opinion again, I think in reality they just got a little bit tired of the contractor coming with all these every month a 2-4 notice, and they just didn't. They took the eye off the ball. But when the suspension happened, there was something like 3,000 unagreed items on the final account. So there was a sole arbiter, a very clever English guy, and there was a number of us went forward for being the party's joint expert, and he had a regime. I got appointed, and he said, because the contractor wanted each of those 3,000 items to be heard at a hearing. A claim for changing the color of something, a $100 claim or whatever. And the arbitrator said, no, this is a waste of proper time. We'll have a parties joint expert, and we'll give him a time limit to come up with a report where hopefully most of the unsettled variations and maybe even the claims for extension of time and so on will be agreed. So we had a time limit, I think it was 3 or 4 months. And I had a team, and they met. My team were allowed to work under me, and they met the engineer and the contractor every day for that period. And I visited and then signed off things every month or so. And when we came to the actual hearing, we had a signed final account on all the measured work. And we had a regime for getting there. We had anything under $100, 50-50, this sort of thing. Right. But it worked. It worked, and it was very expeditious. And that was the enlightened work of an arbitrator called Dr. Robert Gateskill, another man from Keating.
From Keating, yeah.
Yeah.
And he's also an engineer, if I'm not wrong, right?
He's an electrical engineer, yeah. A good man to understand power plants. But I think Ranjit's with us again. On mute, Ranjit.
Well, while he connects, maybe we can close it with one last question. We're already hitting 9 o'clock here. How far do you think this practicable can be stretched? You see, for the employer's claims, for them to be able to raise it within practicable time, how far can this be stretched? A lot of times, I think, I also want to sort of understand this from whose perspective is it really practicable? Is it from the employer's perspective, or are we using it? Are we using a more legal standard of a reasonable person, or from the contractor's perspective? Because from the employer side, I always think that the employer really likes to hold on to its claims, till the end of the project, just so that he can have a leverage of negotiating things where the contractors have raised claims against him, or at the last moment when the employer feels like now it's the time for me to terminate because of the lack of progress. Let's say there's a lack of due expedition, and that the contractor is definitely going to delay this project to the extent that he's not shown his capability, intent, or ability to complete the project, and I feel like I need to terminate, and I wait, right? And for me, it's practicable for me to wait after the termination, or it's practicable for me to wait till the end of the project. So how do you determine what's practicable as such?
I wish I had I thought I had it on my table, a commentary on that case, because some of the claims were thrown out for the Privy Council for being delayed because of a lack of notice.
Okay.
So there is, if someone gets the NHIC NIPDEC judgment or a commentary, I think Fenwick Elliott have got a good commentary on it. There will be some guidance in there, but I think as we've seen, 2017 has tightened that loophole up.
Right.
And I agree with you that employers do save claims up.
Right.
They save claims up for negotiating periods. It's the plus minus thing. If you have more bespoke contracts with no notices or whatever, then you get the plus minus lists. And you get this balancing at the end of the job when the contractor is looking to maximize and the employer's looking to minimize. So the plus minus list will grow from the employer side when he looks at his budgets and sees he's running over on budget. I think 2017 has done a good job in that way. It can't be saved up to the end.
Right. Okay. I guess we've come to the end of our time together, and I just want to once again appreciate and thank all of you, and including David, who's not here with us, but he was able to contribute quite a bit in the discussion. So for those who are viewing us at this late hour, at least in India, we're going to close it up with the last session in the next month, which is going to be on dispute resolution. And that's really what it all comes down to, I suppose. And so I suppose we'll have a good amount of time in discussing more on the notice claims issues, especially, and arbitration and DABs and the possibility of amicable settlements. I think that's quite relevant in the given age where your arbitration costs are skyrocketing, and dispute resolution as such needs to be looked at differently from here on. Ranjit, I know you're there and your audio is weak, but thanks a lot for joining. Paul, thanks again for being here and always contributing to this forum.
Thanks a ton.
All right. Well, that's it.
Thank you, everybody.
Yep.
I will send you a new link for the slides. I do apologize for my last minute tweaking. Okay.
Well, good night.
Thank you very much.
Good afternoon, Paul.